Hi everyone, I'm Kai Ting. Today, we'll be exploring how the fundamental differences between monist and dualist legal system affect a country's ability to comply with international environmental agreement, specifically focusing on climate change and the associated emission reduction targets. At the heart of international law lies the principle of bata sunt servanda, which means that every treaty in force is binding and must be performed in good faith. This is reflected in Article 26 of the Vienna Convention on the Law of Treaties. Moreover, Article 27 of the Vienna Convention emphasizes that states cannot use their domestic law as an excuse for not adhering to treaty obligation. However, the application of international treaties within domestic legal system can be complex, particularly when the system in question are either monist or dualist in nature. So, in this presentation, we will examine the challenges faced by both monist and dualist systems in complying with multilateral environmental agreements. We will also provide recommendations to address these challenges and promote consistent adherence to international commitments across different legal systems. Before analyzing the challenges, I will first explain what monism is and what is dualism. Monist and dualist legal systems are two main approaches to integrating international law into domestic legal frameworks. In monist countries, international law and domestic law are seen as part of unified legal framework. When a country ratifies a treaty like the Paris Agreement, it automatically becomes a part of national law without needing separate domestic legislation. This means individuals can directly invoke international treaties in national courts. Monists that recognize the possibility that courts apply treaty provisions directly as domestic law as well. But we must take note that with the monist system, the hierarchical rank of treaties varies. Some monist countries treat treaties as equal footing to statute. For example, Germany, US. Others place certain treaties above statute, such as France, Japan, Mexico, while countries like South Africa rank treaties below statute. A notable instance of the effective application of international law within the monist system is the case of Agenda Foundation against the State of Netherlands. In this landmark ruling, the Dutch court mandated that the government must reduce greenhouse gas emissions by at least 25% by 2020 compared to 1990 levels. The court based its decisions on various legal sources, including international climate agreements, demonstrating how international law influences domestic judicial decisions. On the other hand, dualist countries maintain a clear separation between international law and domestic law. In this system, international treaties do not automatically become part of domestic law until translated or incorporated into domestic law through domestic legislation or policy. Unlike monist states, dualist states permit only indirect judicial application, meaning the court cannot apply treaty provisions directly. Generally, in monist countries, treaties can be directly applied by national courts without the need for further legislative action. However, the distinction between self-executing and non-self-executing treaties poses significant challenges for monist countries in harmonizing national and international law. The qualification of a treaty provision of self-executing is of paramount importance. In a monist legal system, a treaty that is self-executive does not require any kind of legislation to be implemented within the domestic legal system, while non-self-executing treaties, on the other hand, require domestic legislation to implement their provision. This means that even if a state ratifies such a treaty, it cannot be applied until the necessary laws are enacted. This was evident in the US case, Medellin against Texas, where the application of the Vienna Convention on Consular Relations was discussed. The case also illustrates that the determination of whether a treaty obligation is self-executing or non-self-executing will affect the translation of treaty commitments into judicially enforceable norms. This distinction adds complexity to harmonizing domestic and international law. Courts often have to decide on a case-by-case basis whether a treaty can be directly applied in international law. In some cases, even if the treaty is part of national law, courts may choose not to apply it if they consider it non-self-executing. It can lead to legal uncertainty when the courts must interpret treaty provisions' applicability, potentially delaying enforcement. For example, even in the United States, where treaties are considered the supreme law of the land, courts have often ruled that international environmental treaties like the London Dumping Convention are non-self-executing, as in the case of National Wildlife Federation against Costa. In this case, it was held that the convention did not have any independent effect, and the obligations were based on US domestic legislation. This highlights the uncertainty surrounding the application of international environmental law in monist system. Another issue for monist countries is integrating international obligation into domestic law. If a country already has national law that conflict with international standards, such as pre-existing environmental regulations that are less stringent than those required by an international treaty, it can be legally complex to reconcile these differences. Furthermore, in some monist countries, there is a lack of comprehensive legislative framework detailing how international treaties should be implemented domestically. This can result in ambiguity regarding how to fulfill treaty obligations, which can hinder compliance. The absence of clear guidelines on enforcement and responsibility may lead to inconsistent application of international environmental commitment. For example, the Netherlands faced this challenge when implementing the Kyoto Protocol, which aimed to reduce greenhouse gas emissions. The country had to amend its existing environmental law to align with the protocol's stricter requirements. This illustrates the difficulty of harmonizing national laws with international obligations in monist system. Moving on towards the challenges faced by dualist countries. In dualist countries, most treaties are considered as non-self-executing. Thus, the implementation of multilateral environmental agreements often depends on the enactment of specific domestic legislation. The success of treaties depends on the degree to which they are domesticated. The need for new legislation can lead to delay or outright failure to implement necessary changes. For example, in 2007, the Convention on International Trade in Endangered Species Secretariat reported that nearly 3 decades after the Convention adoption, more than half of its parties still lack fully adequate implementing legislation. The same challenge is seen in Germany with the Convention for the Protection of the Boer Cultural and Natural Heritage. Despite being a dualist country, Germany failed to properly transpose the convention into domestic law, which led to legal and administrative gaps in the protection of natural and cultural heritage. Without specific incorporation of this obligation into national law, it becomes challenging for citizens and organizations to hold government accountable for failing to meet emission reduction targets. This gap can lead to a lack of legal recourse for environment groups seeking to enforce compliance with international standards. Furthermore, when integrating the international treaties, dualist system must address any conflicts between new international obligations and existing national law. This process can be politically contentious and legally complex. If national laws contradict the treaty's version, they must be amended or repealed, which can be difficult in countries with strong political resistance. After understanding the challenges might be faced by the two distinct systems, now you look at some common challenges which both systems might face. First is regarding the judicial discretion. In dualist countries, the general rule is courts cannot apply international treaties unless they have been incorporated into domestic law. This limitation can create a legal gap, preventing citizens and organizations from holding governments accountable for non-compliance with international treaty. Courts in dualist countries may be hesitant to recognize and implement international agreements. For example, Canadian courts, in the Crown Celebash case, acknowledge marine pollution as a national concern, but maintain constitutional limitation on federal jurisdiction for implementing the London Dumping Convention. This restrictive stance contrasts with Australia's approach in Tasmanian Dam case, where the High Court upheld the federal government's authority to enact laws fulfilling international obligations under the World Heritage Convention. While monist countries theoretically integrate international treaties directly into domestic law, in practice, judges in many monist countries frequently are reluctant to apply international environmental law. For example, despite being monist countries, Dutch courts rarely apply international environmental law directly or use it to override national law. They typically rely on national rules and seldom treat international law as an independent basis for decision. In contrast, some dualist countries demonstrate proactive judicial practice that bridge the gap between domestic and international law. Indian courts have shown flexibility by invoking international principles even without formal incorporation. In the Hash acid case, the polluter pays principle was adopted into Indian law based on the passing reference to the Treaty of Rome, which India is not a party to. This highlights the potential for courts to promote compliance with international norms, even in dualist systems. Daniel Bostansky and Jutta Bruni argued that the practical differences between monist and dualist approaches to treaties are minimal. The influence of international environmental law depends more on domestic judicial attitudes than on constitutional framework. Judges who are receptive to the domestic judicial application of treaties can use their judicial power to protect the treaty-based right of private party and promote compliance with multilateral environmental agreement obligations. Although the evolving judicial landscape has blurred the traditional distinction between monist and dualist countries, judicial inconsistency still remains a significant challenge in aligning domestic law with international commitment. This is especially true in countries where courts are reluctant to incorporate international environmental law. Variations in interpretation and enforcement, as in countries like Australia, Canada, and India, highlight the complexities involved. Moreover, political view and national interest significantly influence a country's ability to harmonize domestic legislation with international obligation. Political priorities often shift with changes in leadership, creating inconsistent adherence to international commitment. For example, the US withdrawal from the Paris Agreement under the Trump administration, followed by rejoining under Biden, highlight how fluctuating political will can disturb long-term international obligation. This instability makes it challenging to implement consistent domestic policies aligned with global agreement. Furthermore, national economic interests, particularly in resource-dependent countries, can conflict with international commitment. Australia's prioritization of the fossil fuel industry over emission reduction targets illustrate how economic interests may override global environmental responsibility. Such conflicts makes it difficult to create domestic legislation that balance economic growth with international sustainability goals. When it comes to political will and national interest, the distinction between monist and dualist system is generally irrelevant. Each country's approach depends on its unique political and economic context rather than its legal framework. This country's specific dynamic underscores the importance of strong political commitment and the economic alignment to ensure consistent adherence to international obligation. To address these challenges and improve consistency adherence to various legal systems, here are some recommendations for both monist and dualist systems. Monist countries should assess their national legal system to identify gaps in implementing international obligations. Strengthening institutional capacity, particularly for courts and regulatory bodies, is essential to ensure consistent interpretation and enforcement of international environmental law. This includes providing training and technical assistance to key stakeholders in order to enhance institutional knowledge, improving consistency in applying international law, and fostering greater compliance with environmental commitment. For dualist countries, it was suggested that before becoming a party to an international treaty, dualist countries should incorporate the treaty's provision into domestic law. Countries would first act as signatories until they pass necessary legislation, promoting genuine commitment to environmental protection. This approach enhances accountability and reduces the risk of delays or non-compliance, ensuring that multilateral environmental agreements are not merely symbolic, but fully enforceable within the domestic legal framework. Furthermore, in dualist countries, domestic legislation should be flexible enough to incorporate amendments to international treaties without the need for additional legislative action. For example, the US Clean Air Act enables the Environmental Protection Agency to adjust its regulation for ozone-depleting substance based on changes to the Montreal Protocol. This delegation of authority ensures timely compliance with evolving environmental standards, avoiding the need for repetitive legislative processes. Also, there is some recommendation for both legal systems. Both monist and dualist countries should regularly review their national laws to identify potential conflicts with international obligations. This proactive approach allows governments to amend or repeal incompatible laws before they obstruct adherence to international commitments. Additionally, a compliance committee should be established to oversee the enforcement of environmental agreements. This committee could consist of party representatives or nominated experts with specialized knowledge in the environmental field. The creation of independent body tasked with continuously evaluating the implementation of international treaty is important for maintaining the consistency. This body can track progress, identify gaps, and ensure that domestic laws align with international commitment. Such regular review and oversight mechanism will foster consistency in adhering to international treaties and prevent legal fragmentation. In conclusion, both monist and dualist systems face distinct challenges in harmonizing domestic laws with international environmental agreements, particularly in addressing climate change and emission reduction targets. However, the ultimate challenge lies not only in the legal system itself, but also in the political will and the national interest that shape a country's judicial approach to international obligation. To promote consistent adherence, both monist and dualist systems should strengthen their institutional framework, adopt flexible treaty implementation mechanisms, and establish regular review processes. By fostering a commitment to international environmental standards, countries can bridge the gap between domestic legislation and global sustainability goals, ensuring more effective climate action. Thanks for listening to my presentation. That's all for me. Thank you.